So it's a really good question you're asking. You want to know who pays off joint credit cards in a divorce because they're in both names. Some are in one name, some are in both. You have to understand. You start off with the proposition that they're marital assets. It really doesn't matter in whose name they're in. They're marital assets, so they got to be paid off. Now, having said that, the court might look at usage. They could be in both names for convenience, but it could be that in your case, only one of them is using them. And maybe they're only being used not for marital things, but for personal things. There's situations sometimes where the parties had a joint card, but they've been separated for a year and they're using the joint card. So the guy is separated for a year. The court's likely going to say, you know what? You use these for your household, separated from his or hers. So you know what? You're going to pay those. Remember one thing, the debts are going to be split equitably. That means fairly, but it doesn't necessarily mean 50-50. The one who benefited from that may be held to pay for it. Now, having said that, you got to remember one thing. There's a difference between the relationship between you and your spouse in the divorce court and you and the bank. The divorce court may say that you are the wife, you spent the money, this is not for anybody's benefit, you pay for it. But if both names are on the card, the bank has the right to hold both of them liable and can pursue both of you irrespective of the divorce. Why? Because they're not a party to your case. They're not part of your divorce. Whatever contractual relationship you have with them, they can still seize upon for the purposes of collection. So you may need to be aware of that.